In case there's anyone I have not met in the room yet, my name is Emily Olsen-Galt. I am the Director and Chief Counsel of the ABA Death Penalty Representation Project, and I'm so excited to welcome you all to the 2024 Volunteer Recognition and Awards event. This event is the highlight of our year here at the project because it gives us the chance to honor the incredible work of our pro bono attorney partners. And those people give so much of themselves to their clients, to the cause of justice, that this is the one time we really have where we get to give something back and say thank you. I'm really thrilled to see so many familiar faces in the room tonight, and I know we have many more joining us virtually on the live stream. For those of you who are new to the program, though, we're really glad to have you join us. And tonight we are celebrating what is really the very best of the legal profession, honoring the pro bono service of law firms and individual attorneys who have dedicated their time, skills, and resources to the cause of ensuring due process and effective representation for all. Before we begin, I'd like to take a minute to thank a few of the people and organizations that made tonight possible. First, a heartfelt thank you to all of our sponsors, with special thanks to our defender-level sponsors, Arnold Porter, Kroll and Mooring, Greenberg Traurig, and Skadden, and our champion-level sponsor, Kirkland & Ellis. I'd also like to extend our gratitude to Bradley, whose generous contribution in honor of their colleagues at Arnold & Porter came in just after our printing deadline. So while you don't see them in your program book tonight, they absolutely have our gratitude along with all of our other sponsors. Your sponsorship, your support, your partnership in our work is truly at the heart of all our success. So when we celebrate a victory, you are part of that victory, and we thank you. I also want to thank my incredible staff, Abby Crick, Laura Berg, and Alex Campbell. I think some of them are in the room, some of them are out there, but I know they would all love to talk to you this evening about how you can get involved in our work. I also want to give a thanks to Taylor Smith, our former program associate who left us just about a month ago to attend law school. So we're very proud of her and thank her for everything she did to help plan tonight. Finally, a special thank you to Ayanna Hunter and the DC Public Library. We are new to this venue, but we are so happy to be here and thankful to them for hosting us. I want to turn things over shortly to our next speaker to keep things moving along, but before I do, I decided I really wouldn't feel right if I didn't first acknowledge maybe some not so celebratory things, but things that are going on right now in real time with some of the folks in this room, some of the defense teams in this room. We have at least two teams in this room right now who have clients under death warrants who are innocent, who were denied relief by the courts in the past 24 hours. So it's been a rough couple of days. And I know that nothing I can say is going to make any of those legal situations any better. And I know that the attorneys are going to keep fighting because that's what you do. But I want you to know that whatever the outcome, we are here supporting you. You have our admiration, our respect, and our gratitude for everything that you are doing. Whatever the courts are going to do, and I know you will fight to the very end, your relentless commitment to your clients and to the cause of justice is what we are celebrating tonight. So on that note, it is my pleasure to introduce ABA President Bill Bay, who is a former volunteer attorney himself and also a former member of the project's leadership. Bill was unable to join us in person tonight because of his busy travel schedule, but he has prepared a special video message to welcome you all.
Good evening. It's my pleasure to virtually join you for the 2024 ABA Death Penalty Representation Project, Volunteer Recognition, and Awards Program. I wish I could be there with you in person at the Martin Luther King Jr. Memorial Library. I've come to find that my position on human cloning may be changing. It sure would make it easier to be in multiple places at the same time. Tonight we show our appreciation for the sacrifice and the labor of love of those who fight to make justice real in the lives of their clients. Thank you to Chair Ted Howard, and thank you to Staff Director Emily Olsen-Galt for your leadership and the selfless efforts of staff, members and sponsors involved in the ABA Death Penalty Representation Project. Thank you for your compassion and for helping to ensure that equal justice under law applies to everyone. We are pleased to have the Honorable Elsa Alcala, retired judge of the Texas Court of Criminal Appeals, as our keynote speaker. She's going to tell us about her extraordinary experience presiding over the highest court in Texas to hear appeals in death penalty cases. I do understand the work all of our awardees do and how important it is. Some years ago, I had the privilege of representing a client in a death penalty habeas case, so I know firsthand how hard it is and the sacrifice you make to be part of this. What you do matters. Thank you. It is with gratitude that we acknowledge two recipients of the Exceptional Service Award, Arnold Porter and Bryan Cave Leighton Paisner. It is Arnold Porter's second time winning this award. The first was in 2011. Arnold Porter pro bono death penalty lawyers have a long history of serving in the leadership of the Death Penalty Representation Project, including current committee member and counsel Rebecca Gordon. Thank you for your continued commitment to pro bono death penalty representation and for your work to challenge often cruel and experimental methods of execution. Our other award winner in this category is Bryan Cave Leighton Paisner, who has worked on death penalty matters in many states, but they have had a significant impact in my home state of Missouri, where their firm is headquartered. Their work has exposed issues with the way the state administers its death penalty. We appreciate your dedication. And on a personal note, I've had the privilege of being a co-laborer in bar work for years with Charlie Weiss at Bryan Cave. His leadership in this area has really made a difference. And Ben Clark has been a great friend and community leader for years in St. Louis. Bryan Cave is also near and dear to my heart because my son Peter works in their litigation group there. So thank you for getting a chance to say a personal note. Finally, we also honor the John Paul Stevens Guiding Hands of Counsel Award recipient, Cliff Sloan. He's a professor at Georgetown Law School who teaches courses on constitutional law and the death penalty. Thank you for your years as a partner at Skadden, where you generously devoted your time to pro bono matters and death penalty cases. The 2024 award recipients join a legacy of esteemed honorees. We are proud to honor you today. You make justice real. On behalf of the American Bar Association, thank you and congratulations.
Thank you, Bill, for that wonderful, wonderful welcome. And thank you to the ABA for all your support of the project. I want to give a special thanks to my colleagues at the ABA Center for Public Interest Law, who are here, many of whom are here this evening, who do such a great job, not only in the realm of death penalty representation, but so many other public interest causes, and are making a real impact in the legal community and in the world. So to begin tonight's awards program, I'd like to invite Lindsey Boney to the stage. Lindsey is a partner at Bradley, which is also a past recipient of this award, and he has graciously agreed to tell us about tonight's first recipient, Arnold Porter.
Thank you, Emily, and good evening. It is my distinct honor to introduce to you my friends at Arnold Porter, who are being recognized tonight as a recipient of this year's ABA Death Penalty Representation Award. For the last decade, I've been privileged to see the Arnold Porter team in action on many occasions, both in locking arms as co-counsel for paying and pro bono clients alike, and simply as an observer to their willingness over and over and over again to take on pro bono matters for those who have found themselves in the crosshairs of prosecutors seeking to impose the greatest and most final of punishments. Time is too limited to tell you of all their incredible work in capital cases, or candidly even to capture the full sense of its breathtaking scope. But to be sure, it's an impressive and all-encompassing resume. Their clients have been men and women of varied races and ethnicities, some with powerful actual innocence claims and some not. They have represented various organizations as amici to address critical issues that individual defendants could not take on for a variety of reasons. Some of their matters have required protracted, heated litigation, and others have required skillful advocacy and negotiation in other ways, whether in the executive or legislative branches or behind the scenes. They have advocated and lobbied for systemic change, to protect the rights of all death row inmates, and have also fought vigorously to protect individuals' unique rights. Some of their matters have demanded their steadfast representation for decades. The breadth and depth of their work representing, caring for, and unmistakably fighting for individuals who are facing the real prospect of execution is staggering and awe-inspiring. There is simply no other way to describe it. But my greatest pleasure in introducing this team to you tonight derives from a deeper place. They are not just great lawyers, they are great people, some of whom have become dear friends to me personally over the years. I've experienced the entire range of emotions with this team. We have walked clients off of death row together, vindicating their innocence, and we've faced the doldrums of a client's execution together. And that's where I'll end, with a specific war story that hits particularly close for home to me as an Alabamian. The work by my Arnold and Porter friends on the case of Kenny Smith earlier this year poignantly highlights, I think, not only their unwavering commitment to this seriously important work, but also to their professionalism and humanity. This crowd, no doubt, knows about Kenny Smith, who earlier this year, despite ongoing litigation in multiple courts and unexhausted appeals, was executed by the state of Alabama using a previously untried method of nitrogen hypoxia. Through it all, over nearly 20 years, Arnold and Porter fought for Mr. Smith. And we in our firm was proud to be their Alabama co-counsel. The A&P team, led by Robert Grass and Jeff Horowitz, and made up of a host of others, many of whom are here tonight, boldly, diligently, faithfully, and tenaciously represented Mr. Smith all the way until the bitter end. They exhibited expert care and rarely seen thoughtfulness all the way. They spared no time or expense to devise the most compelling strategy to preserve and develop the many complex issues in the case. And despite the final result, their work will resonate in the capital litigation world for years to come. But what gripped me the most was more than their commitment. Sure, there were countless late and sleepless nights and literally dozens of emails in that terrible twilight zone of 10 p.m. to 6 a.m. for days on end. As the folks in this room know, that's the table stakes in this line of work. But no, for me, the distinctive was their raw emotion and care for Mr. Smith, their humanity. It was apparent in the media interviews given by Mr. Smith's family in the days leading up to and just after his execution. They knew that his lawyers cared about him, and that gave them hope. It buoyed them. It filled up their cup. This next-level representation is something not often seen in our profession, even with paying clients, even less so for pro bono clients. But the Arnold and Porter team led with their hearts while exhibiting a unique professionalism, collegiality, skill, tact, and expertise. In short, this team, the people at these tables and those who weren't able to be with us, are terrific, immensely talented lawyers, but they're great people. My firm is no stranger to pro bono work and the organizational commitment that it requires. As Emily said, we've won this award before, so I feel qualified to say this, and I say it unreservedly. Arnold and Porter is the real deal. They walk the pro bono talk. And these friends of mine who have been born, friendships that have been born in the trenches and now spilled over into real life, have been an inspiration to me and to my colleagues. Their efforts in representing Mr. Smith and their so many other capital clients exemplify the highest values of the legal profession. I'm deeply grateful to know and work with this brilliant team, and proud to call them my friends. So please join me in congratulating Arnold and Porter on this well-deserved honor.
We are definitely better at law than pictures. We'll just rest assured. Lindsey, thank you for that introduction. You all should know Lindsey and I have actually worked together for probably over a decade, closer to 15 years on both commercial and pro bono work. And it's interesting because we're from very different parts of the country. Lindsey's from Birmingham, Alabama, and I'm from New York City, the Big Apple. But what's clear is Lindsey and his colleagues at his law firm Bradley share the same dedication to the preservation of human dignity shared by my colleagues from Arnold Porter that are here this evening and those that are not. So in preparing to talk to you all tonight, it occurred to me that much to, I'm sure my managing partner who's here, much to his happiness, I thought I should look at what we actually say publicly about our pro bono work. So I took a spin through our website. And this statement in particular caught my eye. We are driven to provide equal access to justice. And I wondered, what does equal access to justice really mean? So like all good, high-priced, big firm lawyers, I Googled it. I searched for the definition of justice, but I found that to be less than helpful because the primary definition I kept getting was the quality of being just, clearly written by lawyers. So I persisted, and I found definitions like righteousness, equitableness, and moral rightness. And it seemed to me that I was getting warmer, but then I thought, who decides? Who decides what is righteous or equitable or morally right? What's the standard? Do we just go with our guts and kind of forgive the reference, but Justice Potter Stewart, we know it when we see it approach? So then I did what any good lawyer from New York who also happens to be Jewish did. I went to the rabbi. There's a rabbinical doctrine, I'm told, called tikkun olam, which is a Hebrew phrase that literally means repair of the world. And more conceptually, it means the pursuit of social justice through acts of kindness to perfect or repair the world. And now I really felt like I was getting somewhere. To me, that is what equal access to justice is all about. Doing what's right in pursuit of just causes in an effort to repair the world through the preservation of human dignity. And in my view, this starts with two fundamental principles. First, you got to commit to the program. You got to roll up your sleeves and get involved. And second, you got to be prepared to fight for what you believe is right. Theodore Roosevelt put it best in his famous speech, Citizenship in a Republic. The credit belongs to the person who is actually in the arena, who strives valiantly, who comes short again and again, but who does actually strive to do the deeds. The way I see it, we've got a duty as lawyers to strap on our lawyer helmets, to strap on our lawyer shields, and go into the arena in pursuit of justice. And I know all of my colleagues here from Arnold and Porter, and frankly, I'm sure all of you subscribe to this philosophy, but one of our colleagues who couldn't be here tonight, Robert Grass, whose picture was up before, and I'm hoping we can get up again, he's truly the living embodiment of these principles. Robert's tireless work in the death penalty arena, frankly, is the main reason that I'm standing here today accepting this award on behalf of our firm. Robert's worked on multiple death penalty cases and issues over the years, but as Lindsey previewed, his efforts on behalf of Kenny Smith, the first convicted person, I should say, in the world to be executed by nitrogen hypoxia, were nothing less than heroic. Robert first became Kenny's lawyer about 20 years ago. Kenny had been convicted of participating in a murder for hire in Alabama. This was not an innocence case, but the jury voted 11-1 for a sentence of life imprisonment. But the judge, who had been elected by popular vote, I'm sure you all know what I'm talking about, sentenced Kenny to death under an Alabama statute that allowed the trial judge to override the jury. And although that absurdly unjust law was eventually repealed long after Kenney was sentenced, Alabama, in its wisdom, no offense, Lindsey, decided the repeal was not retroactive, so it didn't apply to Kenney. Under anybody's definition of justice, this was wrong. This was a world in need of repair. Beginning in 2005, Robert led the firm's representation of Kenney in multiple state and federal post-conviction proceedings, but by 2022, after 17 years, all of the claims had been denied or were exhausted. So the Alabama Supreme Court set a November 2022 execution date. So Robert and the team, several of whom are here tonight, brought a method of execution claim challenging Alabama's plan to execute Kenney by lethal injection. As I'm sure many of you are aware, at that point, Alabama had demonstrated a stunning level of incompetence in a series of botched lethal injection executions. And in the two most recent attempts before Kenney, Alabama's death chamber personnel had tried for hours, but had been unable to establish intravenous lines. One of these botched attempts that actually was entirely aborted occurred even after our team had moved to enjoin Kenney's execution. Robert stood up in court and explained to the district court judge that the very same thing was going to happen to Kenney because Alabama's lethal injection personnel had no idea what they were doing. Not surprisingly, the district court dismissed Kenney's complaint 8 days before the scheduled execution, and within days, Robert and our team had fully briefed the case on appeal to the 11th Circuit. Robert argued Kenney's case, and on the afternoon of Kenney's execution date, the 11th Circuit reversed, but they didn't stay the execution. So minutes before the execution was scheduled to start, the district court denied the team's motion for a stay, so Robert went back to the 11th Circuit. While Robert was going back to the 11th Circuit, however, the state had already taken Kenney to the execution chamber and strapped him to the death chamber gurney. He'd been strapped to the gurney for about 2 hours when the 11th Circuit entered his stay. But of course, the state immediately went to the Supreme Court, and I'm sure it comes as no surprise to anybody in this room. The stay was vacated, and the state continued to move forward with the execution. And as predicted, the Alabama death chamber personnel botched the execution. Kenney was strapped to that gurney for 4 hours in total. He was stuck over and over again with needles in multiple failed attempts to place a central line, or to place intravenous lines, including an attempt to place a central line by inserting a needle roughly the diameter of a drinking straw into his clavicle. One of the failed maneuvers involved flipping the gurney with Kenney strapped to it into an upside-down crucifix position. Shortly before midnight, the execution warrant expired. They'd been unable to access a vein. Kenney was still alive. Although he couldn't stand, he couldn't walk, he couldn't dress himself, and of course he suffered from PTSD. At that point, the governor of Alabama was literally shamed into issuing a temporary moratorium on executions, and I wish I could tell you that was the end of Kenney's story. But for the next 10 months, Alabama indicated to us that once the governor lifted the moratorium, it would try a second time to execute Kenney by lethal injection. Then suddenly, on the same day that the state released a brand new, highly redacted secret protocol, Alabama announced that instead it would make Kenney the guinea pig in the first ever execution by nitrogen hypoxia. They were going to suffocate him through nitrogen gas. Once again, Robert and the team went fearlessly back into the arena. They immediately filed a complaint challenging the plan to execute Kenney by this new and completely untested method. After quickly engaging experts and conducting multiple depositions, Robert led the team in its presentation of evidence during a hastily scheduled preliminary injunction hearing. And despite the strength of the case, Robert had put together in weeks, they had no idea, they being Alabama, what was going to happen when they tried to execute Kenny with this method. They had no idea. But despite that, the district court denied the injunction. So another rush to the 11th Circuit. This time, one of the judges we had before flipped. The case was affirmed. And of course, the Supreme Court denied a stay an hour after the execution was scheduled to begin. So Robert found himself standing with Kenny's family, bearing witness to the horrors of the world's first execution by nitrogen hypoxia. Robert's fight to protect Kenny's constitutional rights and to preserve Kenny's human dignity in the face of aggressive, and make no bones about it, it was aggressive moral depravity that was exposed to the world with respect to the inhumane methods of execution used by the state of Alabama. The case ultimately garnered international attention. The world was watching as Robert and the team from Arnold and Porter engaged in tikkun olam, attempting to repair the world through righteous deeds and actions in pursuit of equal access to justice. Thank you. Thank you to the American Bar Association for recognizing the value of these exceptional efforts and others like it. And I'm honored to accept the ABA's Death Penalty Representation Award on behalf of our firm, Arnold and Porter. Thank you.
Thank you, Jeff. I know that is, I can see it on the faces of you and your colleagues. It is a very difficult thing to experience, to relive. The vicarious trauma of it is real, but what you have done is so important. And I think in your program book, there's a quote from Justice Sotomayor, who wrote, "The world is watching." The world was watching because of what Arnold and Porter did. If Arnold and Porter hadn't been there to tell Kenny's story, to tell the world what was happening to Kenny, no one would have known. It would have happened in secrecy and in quiet, but that wasn't the case. The world did watch. The world watched in horror. And when that happens, it sets the stage for change so that it doesn't happen again. So thank you to Arnold and Porter for taking on the burden that you did of going through that in order to tell Kenny's story, in order to make sure the world knew what was happening, and that what happened to him maybe someday will never happen again. So thank you. To present our next award, I'd like to invite to the stage Ted Howard. Ted is the current chair of the Death Penalty Representation Project, and we are so grateful for his leadership of the project. And he is here to present the next award to Bryan Cave Leighton Paisner. Ted, please wait.
Thanks, Emily, and good evening, everyone. Thanks so much for being here and supporting this event. My name is Ted Howard. I am the pro bono partner at Wiley Rhine LLP here in Washington, D.C., and the current chair of the DPRP Steering Committee, a role in which it is my privilege to serve. As a veteran of an 18-year-long battle with the state of Alabama myself, in a case that unfortunately resulted in an unhappy ending, I have firsthand knowledge of the many characteristics of death penalty litigation, direct or post-conviction, that make it such a difficult proposition to which to commit in a significant way by law firms. Unpredictable commitments of time, expense, and human resources, challenging and often novel legal issues arising in the context of an often woefully deficient factual record, utterly intractable adversaries, and more often than not, hostile courts. In many instances, a completely unsympathetic client, at least from the perspective of those on the outside looking in. The unavoidable investment of energy that can be completely exhausting, physically and mentally, under seemingly thankless circumstances. There are almost certainly more that I have overlooked or forgotten. In any event, it is just these considerations that make it all the more remarkable when a firm, like our honoree firms this evening, make that kind of steadfast, stalwart commitment to addressing the injustices confronted by death row prisoners that Arnold and Porter and Bryan Cave have made. Prominent examples of Bryan Cave's truly exceptional efforts to make justice real for its condemned clients in Missouri and throughout the United States are reviewed in tonight's program, and I would enthusiastically urge everyone to review those summaries in full. But suffice to say that the Marcellus Williams case, referenced indirectly by Emily earlier, is fully representative, not only of the daunting nature of these cases and the features I referred to earlier, all of which seem to be reflected in this example, but also of the sort of heroic efforts that Bryan Cave is already, I'm told, in the process of mounting against all odds to vindicate our system of justice and to save the life of someone who certainly appears to be innocent, at least to the satisfaction of the Office of the St. Louis County Prosecutor, whose motion to vacate Mr. Williams' conviction and sentence was so perfunctorily denied this morning. It is for efforts such as this, an unstinting dedication to achieving justice in all of the death penalty cases in which it is engaged, that the DPRP is pleased and honored to recognize my friend Charlie Weiss and his colleagues at Bryan Cave Leighton Paisner with the 2024 Exceptional Service Award. Congratulations.
It's very.
Good evening. My name is Scott Greene. I'm a partner in the Atlanta office of Bryan Cave. 2016, the project came to Atlanta. 2 first-year associates in the Atlanta office attended, came to see me afterwards and said, "Would you please work with us on a death penalty case?" And I said, "Of course," and the firm immediately supported it. We were assigned a case in Louisiana with a death row prisoner at Angola Penitentiary, infamous Angola. We didn't know what we were getting into. Would it be a case of actual guilt, maybe ineffective assistance of counsel, or something different? and it proved to be something different. On December 18th, 1993, Jimmy Chris Duncan, 23 years old, Monroe, Louisiana, babysitting his girlfriend's 2-year-old daughter, feeds her breakfast, puts her in the bath, goes into the kitchen to wash the dishes, hears a thud, goes in, she's face down in the tub, turning blue. He tries to save her, going to neighbors, CPR fails, ambulance called, the baby dies at the hospital. There's an investigation in Monroe by the West Monroe Police Department. Mr. Duncan explains what happened, sobbing in his recorded statement. An experienced investigator in Monroe investigates the scene, finds no evidence of any criminality, no blood, nothing to suggest anything other than negligence. And he recommends to the DA that the charge be negligent homicide. However, the forensic pathologist who conducted the autopsy says before conducting the autopsy, he's convinced there's been rape of the baby and bite marks are evident, and his colleague will support him on that after a further investigation. The DA then upgrades the charge to first-degree murder. There's a trial in 1998. The DA tries it, says Mr. Duncan is a monster, that he must have let the baby bleed out like you would a hog in the back bathroom. After 2-week trial, Mr. Duncan is convicted and sentenced to death. We began our investigation. We found first that these doctors, Dr. Stephen Hain and Michael West, had been responsible for what is now 10 wrongful convictions. Mr. Duncan is the last person on death row convicted because of Hain and West. Much has been written about them. There was a videotape that Dr. West prepared of his examination of the baby, using the dental mold of our client and jabbing it into the baby's body during the course of the investigation. He takes no photographs before doing so, only photographs afterward. He's suspended by the American Board of Odontology, so he can't testify. The state decides to give their new odontologist the photographs, but not the videotape. Videotape was never shown to the jury because the judge determined it was not exculpatory. We found Dr. Lowell Levine. Levine was asked by the state to testify as the odontologist. As soon as he found out that West was involved, he declined. And he said, I'm not going to clean up another West mess. He did not see the videotape until we showed it to him 2 years ago. He was horrified and said that completely corrupted the evidence, destroyed the evidence, completely contrary to any standard of care. We found 2 forensic pathologists who say Dr. Hain botched the autopsy. There's no way upon visual examination you could have concluded that there was anything close to a rape here. And scientific evidence since 1998 have demonstrated that there are many, many other reasons for what was found on this poor baby. And Dr. Hain rushed to the decision that it was a forced drowning after rape. And then he destroyed all the physical evidence. The rape kit that had found nothing was negative. The blood work, the paraffin wax molds of the tissue samples, all the original tissue samples, all destroyed by Dr. Hain. So 2 years ago, the Innocence Project asked to join us with a petition of actual innocence. Of course, we accepted. And I'm very pleased to tell you that beginning September 23rd of this year, 10 days from now, the judge has given us 1 week to present all of our evidence of actual innocence in an attempt to seek a new trial. Our team is very pleased. We hope you will send your thoughts and prayers our way for that week. And on behalf of the Atlanta team of Bryan Cave, thank you very much for this honor.
It's funny that I'm J.C. Andre from the Santa Monica office or Los Angeles office of Bryan Cave. It's funny that Scott mentioned the Atlanta team because one of the things that's so wonderful about our firm is we have these multiple teams doing pro bono death penalty work all over the country. And we coordinate, of course, when we can and help each other out. But we really are, kind of a number of pockets doing our own things, affecting different jurisdictions. And I love the amount of support that the firm has given us. I've only been with the firm 4 years. And in that 4-year period, I've been blessed to have been collaborating with the Arizona federal defenders on 5 of their capital cases. That's a lot of work in a 4-year period. Of course, we're here receiving this recognition based on the work we did in 2023, 2024, and I'll get to that work in a second. But I want to first, really thank all the defender representation organizations and the community defenders who do this day in and day out, because you all and those federal defender and public defender organizations, they're the true warriors here because we have day jobs in big firms. And while we give as much time as we can, we're not there dealing with all the blows that the people who do this full time take day after day. And so I want to recognize them because they are my friends, they are my partners, my collaborators in the work that I do. I adore them, I love them, and I want to thank them in front of all of you and whoever's watching online. So as I mentioned, we're here getting this recognition, and again, thank you to the project for recognizing us for the work we did in 2023, 2024. And unfortunately, with respect to my team, that's where the happy part of this presentation ends. Case number 5 that we've handled with the Arizona Federal Defenders is a case you may be familiar with. Came down on May 23rd, 2024 from the Supreme Court called Thornell v. Jones. And it's the case of Danny Jones. It was the one death penalty case the Supreme Court heard this term, and it was a 6-3 reversal by the conservative bloc with the 3 liberals dissenting, as you'd expect, of a Strickland prejudice finding by the Ninth Circuit. To briefly touch on the case, for those who aren't familiar with it, Danny Jones was convicted of murder in 1993 in Arizona. Of course, that was pre-Ring, so the judge determined his death sentence. He was represented by a public defender who had only 3 years' experience as a lawyer and not any experience whatsoever as capital counsel. He did nothing to build his mitigation case until after the guilty verdict came down, and there was a 6-week break before sentencing. The only thing he did do in that brief period is he requested a unique thing under Arizona law, Arizona Rule 26.5, an independent court evaluator to basically evaluate Danny's mental health and then make a recommendation to the parties in the court about whether further things should be done. The investigator, of course, noted a number of things that should be further explored, and the trial judge, Judge Chavez, said, nope, I've heard enough, let's proceed with sentencing and impose the death sentence. Goes up on appeal, Arizona Supreme Court agrees, goes back on state post-conviction review, back to Judge Chavez, he said, yep, I was right back then, nothing's changed, death sentence stays intact, and now we go, of course, under AEDPA to federal court. Thankfully, our district judge in that instance saw that there was a lot of mitigation that the trial counsel could have unearthed, and he didn't. So the district court held a very rare 2254E federal evidentiary hearing, took testimony over 3 days, and wealths of mitigation evidence came in. But the district judge, applying the standard that we say is wrong, Justice Alito says is right, we said, here, look, you don't get to decide, District Judge Bolton, what you would have done if you sat in Judge Chavez's shoes. That's not how you analyze Strickland prejudice. Instead, Strickland prejudice is probabilistic. You're looking at the reasonable objective sentencer. She said, nope, I'm going to go ahead and deny relief here. Goes to the Ninth Circuit, which reverses and finds that there was, in fact, Strickland prejudice. This is a critical point. This is before Trump became the 45th president of the United States. The case gets vacated by the Supreme Court based on an intervening Supreme Court precedent, GVR, for those of you who are appellate lawyers. Unfortunate, but kind of the right result from a doctrinal standpoint. Goes back to the Ninth Circuit. They again grant relief and say, nope, there was ineffective assistance here. Strickland prejudice was shown. Judge Bolton got it wrong in the district court. Now, of course, we've had an election. The Arizona AG's office petitions for rehearing en banc. 11 Trump appointees to the Ninth Circuit dissent from denial. Goes up to the Supreme Court, and I mentioned what happened on May 23rd, 2014. So I guess where I'll leave this not-so-happy story is, and we all know this in this room, but elections matter so much. If Hillary Clinton was the 45th president of the United States, there wouldn't have been 11 dissents from en banc in the Ninth Circuit, and there wouldn't be a 6-3 majority to reimpose Danny's death sentence. Thank you.
I wish I spoke as swiftly and as well as J.C. Andre, but unfortunately, you're stuck with a slow-moving 70-year-old. It makes Emily nervous when people pull out notes. If you notice, if you want to entertain yourself other than the speakers, keep an eye on Emily, because as we go over, she starts trembling a little bit. It's been really awesome. And I went years without ever using notes anywhere as a matter of, I don't know, sort of macho, but I turned 70 the other day and I just said to hell with it. So these are also useful for this reason. Anyway, I'm Ben Clark. The first thing I want to say is to reiterate what Bill Bay said, that the rest of us at Bryan Cave Leighton Paisner are here because of the guy sitting right in front of me, and he's with his wife, Suzanne. Charlie Weiss is the dean, not in a law school sense, of pro bono and of capital punishment representation in the state of the Missouri. Under his leadership, multiple people have been falsely imprisoned for a quarter of a century or more, have been freed, outright freed, and we wouldn't be here tonight if you weren't who you were, Charlie, so I just want to honor you once again. It's fantastic. And to think that after representing McDonnell Douglas and all these other big corporate clients during the course of a long, and I mean long, he's a lot older than he looks, career, to end it on this note is a real tribute to you, Charlie, and we're all very proud to be seated with you. This case is a case of Parson versus, actually State of Missouri versus Brian Dorsey, who, that case attracted national news. Some of you heard about it. It had all of the elements of the tensions that we see in these sorts of cases. It was retribution of the family and the state versus rehabilitation. Not all of the family, because his family and relatives have broken apart to some extent based on the fact that some of them actually supported keeping Brian alive. Involved vengeance versus forgiveness, the same sorts of issues we face in these cases all the time. The facts lend themselves to the attention that this case got. Severe depression suffered by Mr. Dorsey for a lifetime. He committed a heinous crime, and admittedly so. It's not an innocent situation. This was all about whether the governor or the Missouri Supreme Court would commute a death sentence and let him remain in prison alive for the reasons I'll get to in just a moment. A drug-induced psychosis led him to actually shotgun murder his cousin and her husband. After they essentially saved him from two very predatory crack cocaine drug dealers who had come to him to collect a past due debt. They saved him. Things went crazy one night. He killed them. What was the state's response? Well, the state public defender at the time was operating under a fixed fee rule whereby attorneys would be recruited, and for X dollars, they would defend a capital case. Well, two of them were $12,000 apiece. Think about that, to defend from start to finish a capital case that usually involves thousands of hours, and that on average projections would have resulted in payment to these attorneys of $3.37 an hour. Now, the unusual plea deal that resulted from that apparent conflict of interest, the conflict of interest being the right to zealous representation, contrasted with the economic interests of the attorneys who get appointed. That fixed fee arrangement, by the way, was discontinued by the state of Missouri at the instance largely of the American Bar Association, so thank you and yours, Emily, because it was found that there was an inherent conflict between, if you pay a fixed fee, particularly if it's a microscopically small ones, such as these two attorneys face, you are not incentivized economically to zealously represent. And I don't, the two attorneys involved, I'm not to say, it's not my place to say, but they've defended themselves and they have not admitted that there was an economic aspect. But there was an unusual plea agreement that was reached, which was sort of the center of the story, one of the centers of the story that the Times and CNN and LA Times took an interest in, and that was that they pled out Mr. Dorsey to first-degree murder, which requires premeditation and which opens the door to a death penalty, as opposed to negotiating down on the facts of the case, given his psychotic state of mind, to second-degree murder, which eliminates the death penalty. And they did so without getting an agreement as to what the sentencing would be. So that was signed off on. I'm sure the government gleefully signed off on that. One of the things that happened when they went straight to the death penalty jury, in addition to telling them that he had pled to first-degree murder and implying that there was all the intent there, was that there was some very dubious evidence advanced, not through the charges of the government, but at sentencing, in the sentencing proceeding without objection, that one of the investigators had smelled bleach on the crime scene, and that led to his conclusion that after being murdered, the cousin had been raped by Bryan Dorsey. As you can imagine, that's extremely powerful evidence to put in front of a sentencing jury, and essentially uncorroborated. I'm not sure if it was objected to or not, but it came in, and you can imagine what the result was. So he was sent away. So the years go by, and within the last few years, as we approached the various appeals, habeas corpus and others ran their course, we were approaching the execution date. 70 plus prison workers, officials, wardens, people who had been with Dorsey all these years wrote a letter at great risk to their own jobs to the governor of Missouri saying, please, this is the example that proves the rule. This person, if anybody does not deserve to be executed, it's Bryan Dorsey. He's been a model prisoner. He's in the honor dorm. He is the barber. This is strangely in the prison, as some of you know, it's sort of a coveted and important position. He would flat blade razor the warden every other week. I mean, there was this incredible, he did all the haircuts. He was, in short, the reason you try to rehabilitate people. And so in addition to 70 plus people writing the governor, which the New York Times described as a rare, unprecedented event in American judicial history, there were bishops, there were mental health organizations who came out and said, this is going to be pointless. You don't execute people like this. Please commute. We're not asking he be made free, set free. We are simply asking that he can serve a life sentence out, being the model citizen, which all of these prison officials are asking you to let him be. Unfortunately, that, among all the other evidence, did not impress our governor. Mike Wolfe wrote that allowing execution of Mr. Dorsey would dishonor our system of capital punishment. Well, why does that matter what Mike Wolfe said? Well, because he was one of the Missouri Supreme Court judges who affirmed the conviction to start with. And Judge Wolfe came out, and this has never probably occurred in a case like this before, somebody who had actually ruled that the execution should proceed came out and said, if we knew then what we knew now, the result would have been different. But we didn't know about this plea situation. We didn't know about the other evidence. So he besieged the governor to let this man serve out his sentence as everybody wants him to, across the country, everywhere, do it. Well, in Missouri, that doesn't happen. It doesn't happen, and that was ignored. So how did this remarkable, tragic series of events come to an end? Well, at 6:11 p.m. on April 9th, Mr. Dorsey was pronounced dead by lethal injection. To the tears of many, including those who usually don't cry about these things. So, and of course, the next day on the docket, the docket entry was suggestion of death, case dismissed. You got check the box, another one. So we were proud to represent him, and we accept this award on behalf of the many other lawyers and law entities that helped us and helped us get to the finish line. You know, everybody in this line, everybody in this room is engaged in a noble pursuit. And you don't want to pat yourself on the back too much, but we know we're going to lose most of the time, and we fight for it anyway. We fight for it anyway, right? And Bryan Cave says, and we say internally, I say to you tonight, keep on fighting, because it's worth the fight. We're very grateful for the award, and we're proud to have received it. Thank you.
Good evening, everyone. I'd like to start off by thanking all of you in the room who are involved in the death penalty representation and in innocence work. It is important work that we all do. Ben, JC, and Scott are all outstanding trial lawyers, aside and apart from what they do in this representation work. So when you have people like that are willing to take on these cases, it is really a great thing for the defendant in these cases. Many of us believe that there's life after death, but there's no life after death on this earth. And death is final. And one of the problems with the death penalty in our society is it is final. And as we all know, our litigation system, Department and Administration of Justice is run by human beings. We're all fallible, and we make mistakes. And innocent people are convicted, and it is rare, but innocent people are put to death. Most of us, firms like Arnold Porter, Bryan Cave, we do this work pro bono. We do it because we truly believe in justice. And I can't imagine more of an injustice than executing an innocent person. This work is not for the faint of heart. It requires persistence, perseverance, focus, and steadfastness. These cases are difficult. There's no magic bullet to most of them, and it takes years to do. And so, again, I congratulate everyone in this room who's involved in this. The case that I'm currently involved in is one of the cases that Emily mentioned. We heard today, as I was on the airplane coming up here, that our case, the Marcellus Williams case, was denied by the trial judge. It's a case that's been going on. He was convicted. It's a terrible case. Involves a young couple, a woman and husband in their 40s. She was a St. Louis Post-Dispatch court reporter for 12 years. Her husband was a young doctor at Barnes Hospital, Washington University in St. Louis. He came home one night and found her lying in the hallway next to the front door, stabbed 43 times with the knife still in her neck. I can't imagine a worse crime than that. Crime went unsolved for almost a year. The police talked to the husband and said, it might help if you posted a reward. And he did. He posted a $10,000 reward. This case had a lot of publicity all in the newspapers in St. Louis, TV, radio stations, and that was also well publicized. Shortly after that, a prisoner that was in one of the St. Louis jails, had been there for months, was just released. And as soon as he was released, he approached the police and said that he had some information about the woman who had been killed and stabbed in University City. University City is a suburb of St. Louis. The first thing he asked when he came to the police is, what about the reward? How do I get that? And he told the story that his fellow prisoner that he was in jail with had confessed to him that he committed the crime. He also said that the prisoner had a girlfriend and you ought to talk to the girlfriend. Police did talk to the girlfriend. The third time they interviewed her, she was about ready to go to jail on another charge, and they told her they could help her if she came forward, and she did. She finally said, he also told me that he had committed the murder. So the only evidence at trial were the two snitches, the one, the jailhouse snitch, and the former girlfriend. The former girlfriend was a longtime prostitute, drug addict, been in and out of jail, in and out of rehabilitation. Also had been a snitch for the police on occasions. But anyway, at trial, he was convicted and sentenced to death in 2001. In 2015, in a habeas case, the Missouri Supreme Court ordered DNA testing on the knife that was left in her neck. They had, and I should say this, that no evidence at the crime scene identified our client. There was blood, that was not his blood. There were bloody footprints. They didn't match his shoe size. There was all sorts of hair left at the scene. None of it matched him. So nothing matched our client at the crime scene. There were some fingerprints there, but they were smudgy. And prior to the trial, the prosecution had discarded the fingerprints, saying they were ineffective and couldn't really be used. They had tested the knife handle for fingerprints, found none. They did not test the knife handle at that time for DNA. So in 2015, the court ordered DNA testing on the knife handle. And there's 2 male DNAs found on the knife handle, unidentified. And so that began our involvement in the case. He was about to be executed in 2017 when our governor at that point, Greitens, ordered what they call a board of inquiry. Under our statute in Missouri, a governor, when he decides clemency, can appoint a board of 5 retired judges. Those retired judges are to act in confidence, do whatever investigation they can, and then file a written report and recommendation to the governor. That was done in 2017. In 2020, and we got involved in about 2018 and worked with the Board of Inquiry about asking them what they should. There was a similar crime that occurred also at the same, about within a month in St. Louis, where a woman had been stabbed, left with a knife in her neck. But in any event, nothing happened till 2023, and the governor, we changed governors, and the new governor then in June of 2023 disbanded the Board of Inquiry before it made a report and recommendation. We got involved, our client had gone to the Midwest Innocence Project in Kansas City, and they took the case several years ago. They also enlisted Barry Scheck's firm, the Innocence Project in New York. And then they also asked us to get involved in about 2018, 2019, which we did. We had asked the Supreme Court to delay. He had been after they disbanded the Board of Inquiry. The Supreme Court also set an execution date for September 24, a little over a week from now, and that date is still set. We asked several times that the date be withdrawn and reset. The court wouldn't do it. But in any event, we were supposed to have. In the Missouri, there's an innocence statute which allows any local prosecutor to file an innocence statute if they have clear and convincing evidence that the person is innocent. And the prosecutor does that, not anybody else. And in this case, the St. Louis County prosecutor, who prosecuted this case a long time ago, now we got a different person involved, but he filed an innocence project in January of this year, an innocence motion. And that was to be, an evidentiary hearing was to be held on August 21. The day before August 21, I got a call from our people who were working on the case that said the prosecutor had changed their mind. They had thought about, they didn't think they could prove an innocence case here. I should tell you also that the 2 snitches have been dead for years, so they're no longer around. But they talked to the defendant, Marcellus Williams, and it was agreed that the prosecutor, that there would be the prosecutor and Marcellus Williams, there would be a consent that his conviction would be vacated. He then would plead guilty in an Alford plea, and he'd be sentenced to life imprisonment. The reason he did that is he's still in prison, and he's serving prison. He had a 50-some year term for other crimes, and he's still got about 35 years to serve on that. So he's in his late 50s now. So I think he thought, well, I might as well do this and get rid of the death penalty. Before that day ended, then we had the evidentiary hearing on the 21st. This case was presented to the judge. The judge signed off on the consent agreement. By the end of that day, the Attorney General's office, who was involved in the case, filed a motion to vacate the consent decree, the consent, that day. And by the end of the day, the Supreme Court had ordered the judge to withdraw the consent agreement and to set it aside and to have an evidentiary hearing. We have an evidentiary hearing last week on the August 28th. We submitted findings of fact and conclusions to the court. He was going to rule tomorrow, the 13th of September. And when I got on the plane today, I got messages that he had ruled today, denying our motion. So he's going to be executed on the 24th of September unless something really turns around. We've got our Supreme Court has had this case 3 times and has written 3 opinions on the case, all very critical. And so I don't have a lot of hope that if it gets to our Supreme Court that we're going to win there. Anyway, these are tough cases. That's my story, and we'll keep fighting.
Thank you, Charlie, Ben, Scott, JC. We really appreciate you sharing your clients' stories with us. I also have to say, on a personal note, one of the things I appreciate the most about Bryan Cave is that you keep taking my calls. I remember the Jimmy Duncan case, trying to get that place, looking at those facts and thinking, what law firm is going to want to touch this with these horrible allegations and such a young victim? And Bryan Cave saw past that. They saw that something had happened here that was not just, that was not fair. And I think it was Charlie, or maybe it was Ben, that mentioned lost causes. You all see the lost cause, and you see the person behind it. You see the humanity of the client behind that lost cause, and you fight anyway. And that is extraordinary. Among groups of extraordinary people, that makes you even more extraordinary. It sets you apart. So thank you. Thank you for taking the lost causes. I'm now going to invite Kelley Henry to the podium. Kelley, as many of you know, is the chief of the Capital Habeas Unit in Nashville. And in 2019, she received the award that she is about to help present. She is also a member of the project steering committee and an extraordinary advocate for her clients and for improving the criminal justice system. Welcome, Kelley.
Good evening. It is my incredible honor and privilege to introduce the recipient of this year's John Paul Stevens Guiding Hand of Counsel Award to my amazing friend, Cliff Sloan. As many of you know, Cliff Sloan has demonstrated a career that shows the best of the legal profession. He has, through his work at Skadden, done so many amazing things as with the pro bono program there, in addition to his civil practice. You know, I can't read prepared remarks. Okay. I don't do well with prepared remarks. I had the privilege of meeting Cliff through our mutual friend, Laura Burstein, in 2020. Cliff became a partner with me very much behind the scenes for the Purvis Payne case. Many of you all have heard about Purvis Payne. He was the subject of the last decision of Thurgood Marshall in the Supreme Court that overturned the case of Booth versus Maryland. Turns out Purvis is innocent, but also he's intellectually disabled. And were it not for the work of Cliff and his team on behalf of his client, Bobby Moore, Purvis Payne would surely be executed by today. But Cliff, through his work at Skadden, took on Bobby Moore's case and took Bobby Moore's case to the Supreme Court twice in 2 years' time and won twice in 2 years' time, overturning Texas's ridiculously outdated definition. Well, it was never an acceptable definition of intellectual disability. Let's just be very clear. But Cliff proved it. And not only is Bobby Moore alive because of Cliff's advocacy, many folks who were on death row who suffered from intellectual disability are alive because of Cliff's work. Cliff left academia to join, or left the legal field or the firm of Skadden to join academia at Georgetown. And I have to say, I'm very sorry that the Hoyas did steal Coach Cooley from my Providence College Friars. Nonetheless, he has been at Georgetown where he has this incredible practicum of law students, many of whom are here tonight. Yay! Go Hoyas! And I have had the opportunity to work with those students the last 3 years thanks to Cliff's friendship, and I can say that he is an incredible teacher and an incredible mentor and an incredible author by his book. And it is such a privilege that Cliff asked me to introduce him tonight. Fun fact, Cliff clerked for Justice John Paul Stevens, who was the recipient of his Eponymous Award at the first event here in 2011. So it's come full circle for Cliff to receive the award in the name of his justice. So please help me in welcoming and congratulating Cliff, this year's recipient of the John Paul Stevens Guiding Hands.
Well, thank you so much, Kelley, for that very generous introduction. Thank you for our work together. Thank you for our friendship, and thank you for everything that you do day in and day out. And thank you, all of you, for being here. And above all, thank you to the ABA Death Penalty Representation Project and the one and only Emily Olsen-Galt for this amazing honor. It is so meaningful and so moving for me to receive an award in the name of Justice John Paul Stevens. As you've just heard, I had the incredible good fortune of clerking for Justice Stevens. And in fact, it was while I was clerking for Justice Stevens that I first became immersed in the death penalty through last-minute requests for stays of execution and cert petitions and merits cases in capital proceedings. And on the death penalty, as on so many issues, the lessons that I learned from Justice Stevens have inspired and guided me every day. He truly is my guiding star. So I want to mention briefly three things: the Bobby Moore case, the communities that have been very important to me in my death penalty work, and a bit more about Justice Stevens. The Bobby Moore case vividly illustrates everything that is wrong with the death penalty. You know, one person who studied it very closely said that there was one reason, and one reason only, why Bobby Moore received a death sentence: for a convenience store robbery gone wrong that resulted in the unintended killing of a store clerk. And it was the toxic combination of race and geography. Bobby was a black man who killed a white man in Houston in 1980. And Bobby's lawyers at his trial and his sentencing proceeding were an abomination. One of them eventually was disbarred The other died soon after the trial of alcohol poisoning. And none of that had anything to do with Bobby's Supreme Court cases. Those were about intellectual disability. Bobby suffered through an abusive and difficult childhood, and it now is clear that he was intellectually disabled. At the age of 13, he didn't understand the days of the week, the months of the year, the seasons, how to tell time, the concept that subtraction was the opposite of addition. And in 2002, as many of you know, the Supreme Court issued its landmark decision in Atkins versus Virginia, in an opinion by Justice Stevens, that held that it is unconstitutional to execute somebody who is intellectually disabled. And as was mentioned, Texas promptly adopted a preposterous standard for determining intellectual disability in capital cases. It relied on erroneous and harmful lay stereotypes, and it rejected clinical standards. Now, in Bobby Moore's 2 Supreme Court cases, the Supreme Court emphatically repudiated that standard and ruled that it was unconstitutional. And I have to tell you that we're going to hear from Judge Alcala shortly, but her dissents in the Texas Court of Criminal Appeals in Bobby's cases played a tremendously important role in getting the Supreme Court's attention and in leading the Supreme Court to the decisions that it reached. So thank you, Judge Alcala. But sadly, many people in Texas had been executed before Bobby's cases under that notorious unconstitutional standard. And since Bobby's cases, as Kelley alluded to, nearly 20 death sentences in Texas have been invalidated as a direct result of Bobby's case, and death sentences have been invalidated in other states as well as a result of Bobby's cases. It was the honor and privilege of a lifetime to represent Bobby Moore in his Supreme Court cases, in the state courts after remand, and eventually in his successful parole proceeding. In 2020, after Bobby had been in prison for 40 years, almost all of them on death row, he received parole and he was released and he's doing fine. Now, the communities that have been important to me in my death penalty work, and first and foremost, of course, is my family. They've been incredibly supportive every step of the way. They have been incredibly supportive in every possible way. And then there are my 2 most recent professional families, Skadden and Georgetown Law School. I was at Skadden when I worked on the Bobby Moore case and other death penalty cases, and what a joy to work with people like Don Salzman and Ron Tabak and Nancy Buckner and the entire Bobby Moore team and the lawyers I worked with on other death penalty cases and the lawyers at Skadden I continue to work with on pro bono cases. The firm completely embraced and supported my death penalty work, and I am very, very grateful to it for that. And the same is true of my current professional home, Georgetown Law School. From the time I mentioned to Georgetown Law Dean Bill Traynor that I would like to figure out a way that students could get involved in a meaningful way in capital defense, working with capital defense lawyers, and also to figure out additional ways that students could get immersed in the death penalty. Bill was immediately enthusiastic and excited, and he and others made it happen. And at Georgetown, I'm blessed to have remarkable faculty colleagues with tremendous expertise in the death penalty, including the legendary Steve Bright. And I also am blessed to have deeply engaged, wonderful, sensational students, many of whom are in the house tonight. So thank you, students. And I just want to briefly mention 3 other communities that have been important to me. I, too, want to thank the full-time capital defense lawyers who do this work, which is difficult and challenging and grueling, day after day, year after year, and do it with such determination and commitment and persistence and inspiration and innovativeness and effectiveness and resilience. I stand in awe of you. And I also, another community that has been very important to me is the community of lawyers at law firms who do the pro bono work on capital defense cases. And they do it, they contribute so much talent and energy and resources and time. And their contributions are extraordinary and absolutely essential. And last but definitely not least is the community of individuals on death row. I grew very close to Bobby Moore. He one time said that I was his big brother, and I've never received a higher honor. And of course, as you've heard, we have Anthony Graves with us tonight, completely exonerated after 12 years on death row, and now devoting his life to criminal justice reform and making a difference. And I and others in the room are very pleased to be working with Anthony on his very exciting new initiative of the Peer Navigator Project, and I strongly urge you to find out about it. And then finally, a bit more about Justice Stevens. You know, on the death penalty, as on so many issues, he was deeply principled, deeply thoughtful, deeply insightful, and scathingly honest. And let me just give you a few examples. I could give you many. In Atkins versus Virginia, the intellectual disability case, he responded to originalist objections by saying that our constitutional vision is not defined by the rules that governed Lord Jeffreys when he presided over the bloody assizes in 1685, nor is it narrowly circumscribed and limited by the attitudes and outlooks that prevailed in 1791. In another case, in a dissent from a Supreme Court decision upholding the Alabama statute that you heard about that allowed a judge to reject a jury's determination of life and substitute instead the judge's determination of death, a case that was brilliantly argued in the Supreme Court by Ruth Friedman. In dissent in that case, Justice Stevens called the Alabama statute perverse and fundamentally unfair. And while Justice Stevens was one of the justices who voted in 1976 to allow the reimposition of the death penalty, provided that there were what he and other justices viewed as robust procedural safeguards to provide fairness, he eventually and straightforwardly concluded that in light of subsequent developments, including the Supreme Court's conspicuous narrowing and weakening and evisceration of procedural protections in capital cases, and including the many exonerations of people on death row, people like Anthony Graves, which Justice Stevens said is something nobody imagined in 1976. In light of those developments, he said, the death penalty must be abolished. Now, one last point about Justice Stevens. He believed very strongly, he believed in his bones about the importance of pro bono work. He had seen its importance in his own development and practice as a lawyer. He had seen its importance in his work as a judge and a justice. And it was his very deeply held view that it is a fundamental responsibility and obligation of every lawyer, or as he put it, of every good lawyer. And everybody in this room tonight is very much in that spirit and legacy. And I know that based on the work that the people in this room are doing and will continue to do, along with the tremendous work of the ABA Death Penalty Representation Project, That spirit and legacy is going to continue and grow and expand and be as strong as humanly possible. So thank you again for being here. Thank you for this incredible honor. It means the world to me. Thanks very much.
Thank you so much, Cliff. In addition to my day job at the ABA, some of you know I also teach a habeas practicum at Georgetown, and for several years now I've told the story of Bobby Moore and the Bobby Moore case, and told my students what an incredible accomplishment it was, and that no other lawyer could achieve this, going to the Supreme Court twice on the same case twice and winning twice. And I am so grateful to you for your dedication, your passion for this work, and for setting a standard that others can try to look up to and achieve. Certainly, the law students in this room, I know, admire you greatly, but those of us practiced attorneys as well. So thank you, Cliff. So last, but certainly not least this evening, I am delighted to introduce our keynote speaker, Judge Elsa Alcala. Judge Alcala began her career across the courtroom well from a lot of the folks in this room, working as a prosecutor in Harris County, Texas. She worked on everything from minor offenses to capital cases. And she was eventually appointed by then-Governor George W. Bush to the 338th District Court, and later by Governor Rick Perry to the First Court of Appeals. And what she is known for most by most people in this room is her appointment to the Texas Court of Criminal Appeals, where she served for 8 years. I know this is a court that a lot of you in this room know well, maybe too well, you would think, and that's no surprise because Texas, at the time of her service, was the most active death penalty case in the country. And this gave her an extraordinary view into the inner workings of the capital punishment system and the problems with the capital punishment system. During her time on the bench, she authored numerous opinions, and Cliff mentioned 2 very important dissenting opinions she authored in the Bobby Moore case. In her dissent, after the first time, the Supreme Court had told the CCA it was wrong. The case went back. The CCA again denied relief, and Judge Alcala dissented again. And she wrote that she's in good company. And that was absolutely the case. I can only imagine the vindication when the Supreme Court again told her that she was right and that she was indeed in good company. At the end of 2018, after nearly 2 decades total on the bench, Judge Alcala retired from the court and began to focus on policy and advocacy work. She became the policy director for the Texas Defender Service, who are friends and colleagues there. TDS is a nonprofit organization that is focused on death penalty reform, among many other things. And in that role, she has co-authored proposed legislation aimed at judicial reform, including the bills addressing the execution of individuals with severe mental illness, the use of junk science, and the access to habeas relief for people who did not receive adequate representation. Judge Alcala also serves as a board member for the Innocence Project of Texas and the Anthony Graves Foundation. Her career has been truly marked by a commitment to ensuring that the justice system works for everyone, not just those with means, and we are truly honored to have her here this evening with us to share her perspectives. Welcome, Judge Alcala.
Good evening. This is a pretty impressive bunch of people, I have to say. You're quite intimidating, especially when a lot of the complaints are about judges and the courts in Texas. It's a little difficult to get up here, but I'll try to do the best I can. And that is to say that your complaints are completely understandable, and it took me a long time to get here, but I agree with you that there are many systemic problems that need to be addressed. I was a prosecutor in Harris County, and I did try 2 death penalty cases. Neither of the people were executed, but I am now firmly in the anti-death penalty group, and I'll talk a little bit about that, but I thought I would clarify that at the front end because I think that's an important thing to know, that I agree with you that the system is not working for a large number of reasons. I think the only good thing you can say about the system is that there are people like you all involved in it, and that because of the work you're doing, maybe some people will get the justice that they've been deprived for many years. About 8 years ago, I was at dinner with my then husband and 2 couples. 3 of us were, at the time, judges. I was on the Court of Criminal Appeals, and 2 of them were at local Harris County judges in Houston. And, you know, we had shop talk, much like I'm sure y'all have had all night. And one of the judges asked me, Elsa, why are you dissenting so often in death penalty cases? And I said that the system is so flawed that there's a real risk that an innocent person might be executed. I thought that was going to be the end of the conversation. It wasn't one I really wanted to have while I was trying to have a couple of mixed drinks at a steakhouse. But the judge told me, well, that's just a price that society has to pay for the system that we have. And I was appalled by that, from anybody, but certainly from a judge who was presiding over death penalty cases. And I think that, in a nutshell, may summarize the problems with the Texas judiciary. I certainly don't have any experience with other high court judges to where I would be able to speak for any of them. But I can speak for what I saw in Texas with people that I knew that presided at the trial level and at the Supreme Court level. And I think that is a problem. One of the current judges on the Texas Court of Criminal Appeals has made very similar comments, that basically this is just a price we have to pay and that they're going to accept the fact that an innocent person is executed. I think that is just a fundamental flaw with our system. If anybody thinks that that is okay, they have no business being on the bench. I don't think they have any business being a lawyer, frankly. I just don't think that's acceptable at all, at any point. I've tried to ask myself why, and I'm sure y'all have asked yourself that a million times. Why do judges think that, or why do judges think that, you know, this messed up system is okay? And I'm not sure I have a really good explanation. I've tried to figure it out over the years, try to psychoanalyze the people I was working with. You know, why are you using that standard in the Moore case that doesn't make any sense to anybody? And the only thing that I've been able to come up with is that it has to do with a mindset of a belief that the system is generally working. And I'm hoping that this is going to age out with some of these folks who have had that view for a long time. The only thing I've been able to figure out is that, you know, back before DNA, I was a prosecutor in 1989, and under Johnny Holmes, who was the most active death-seeking DA, I think in the United States, but certainly one of the most active death-seeking DAs. And back then, we thought if you had an eyewitness, that was perfect. If you had a confession, we believed that those were always taken by police correctly, and that was considered gold. We didn't really look that much beyond that, and the defense bar really didn't test us to go much further beyond that. And frankly, Harris County juries didn't expect much more. You could call your eyewitness, the jury would hear the eyewitness, or the jury would hear the confession, and that was pretty much the end of the story. They would convict. And I think a lot of my contemporary prosecutors and judges came through that system about the time that I did, and frankly, some were there before I was there. And they believed in that the system was infallible. They believed in police, they believed in prosecutors, and nobody really tested that too hard. For me, the change came gradually, and for many in Texas, and I certainly don't want to suggest I'm the only one, there's certainly plenty of people in Texas who have gradually changed along the way. And that has come through, thankfully, the use of DNA evidence. Now, mind you, when I was a prosecutor in the early 1990s, when we first started having to decide whether to use DNA, when I went to training sessions, originally we were told, you don't need to get that DNA tested. The jury's not going to understand it anyway, and it's going to take a long time, and it costs a lot of money, so just try your case without the DNA. Now, that changed, obviously, along the way, but that was the original mindset. Again, we were winning all of our cases with the juries that we had in Texas with eyewitnesses and confessions. You really didn't, as we saw it, need a whole lot more than that. Gradually, obviously, people started realizing if there's DNA evidence, you gotta test it. And gradually, people started realizing with the DNA evidence that a lot of those confessions aren't good. You got the wrong guy, and he confessed because of pressure or any number of other reasons. And the eyewitnesses weren't good, not because they set out to do a false identification, but because they believed it was the person. They just got it wrong, as is understandable, given the way that some crimes happen. So as DNA came forward, many of us started realizing that the system that we had believed was infallible was in fact very fallible. But frankly, that still wasn't good enough for a lot of people. And so now I'm going to fast forward to when I got on the Court of Criminal Appeals in 2011. I was placed in a position of having to decide whether to continue to apply the precedent that had been applied in the court for the last 120 years. Now, mind you, that precedent was written under the belief that confessions were all valid and eyewitnesses were correct and that sort of thing. So the precedent was very skewed against defendants, as you all know, I'm sure. And it was tough for me at the beginning coming into the court because on the one hand, I wanted to be respectful of precedent. Recently, Justice Ketanji Brown Jackson gave a couple of interviews because she's written a book. And she said on TV very recently that the judges on the Supreme Court, don't consider their personal ideology and that sort of thing because judges are trained to set that aside and to make their decisions based on the law. And that's fair enough in most of the cases. I think you can say, where there's clear-cut black letter plainly written law, it doesn't really matter who's wearing that robe. Most judges are going to come out the same. That's why most decisions are going to be, 7-2, 8-1, 9-0, at least in Texas. And I think even at the U.S. Supreme Court, the vast majority, I think there's close to unanimity. But where there isn't unanimity, and you have these split decisions that are, 4-4-1 or 5-4, where there's a lot of disagreement, that is where personal ideology does come into play. And so I disagree with Justice Jackson to that extent. Now I understand this is way too complicated for, the View to go into this kind of detail. But the reality is that it does matter who is wearing the robe, and it does matter what that person's ideology is. I know that you all know this, but the public is sold this idea that judges just, apply black letter law and it's that clear cut. In Texas, we elect judges, and as you heard, at the time I was a Republican, I'm now a Democrat. But in Texas, everybody was a Republican. That there really wasn't a Democratic Party when I was making that decision in the late 1980s. But when I used to campaign at events, I used to say, judges don't legislate from the bench. And, a huge round of applause would always follow that line. And it wasn't until much later that I thought to myself, well, what does that even mean? I mean, judges don't legislate from the bench. It really is just a nonsensical line. If there's plainly written statutes, judges take an oath to apply the law as written. But many times at the high court level, the whole reason why a case is at the high court level is because the statute or constitution is not plainly written. And that's when the judges have to make the decision based on extra textual considerations. And those are, I wouldn't call them subjective, but they certainly lend themselves to the ideology or the personal values or common sense or experience or training or whatever else of the person wearing the robe. And so I think it's much too simplistic that the bill of goods that the public's been sold, that that judges don't rely on their own personal judgment and common sense and values. I think we all know in this room that we do. And I think when people hear otherwise, I think it is misleading and in many ways untrue. And the reason that matters is because when I got on the court at 2011, I was having to face the decision, do I apply this long-term precedent that the court has that skewed against, in many ways, against defendants and in favor of procedural barriers and that sort of thing? Or do I say we need to abandon that precedent and do something else? And that was difficult because when I joined the court, it was 8-1. I was the only one saying we need to abandon precedent. And the reason for that was because the court hadn't changed composition in 10 years. I was the first one on the court after it had been the same people for a decade. The court had no people of color for 10 years. But when I got on it, I was the first one in a decade. In the history of the court, I was the first Latina. In the history of the court, there had been 2 black males, three. 2 of them, I think, lost their elections within a year of joining the court. Only one of them was actually elected to a 6-year term. So the problem was that in the history of the court, the precedent had been written essentially by white Anglos of privilege in a state that believed that police officers caught the guilty person. And I know I'm probably not saying anything that y'all don't already know, but I do think it matters to hear a first-hand account and to maybe tell you, no, it's not your imagination, that really did happen and does happen. So why in this posture did I finally, in many people's eyes, see the light and come to the other side? And I think what happened was it was just one case after the other where I would see what was going on and I would think, that can't be right. And then my colleagues would, do whatever they were going to do. And then another case would come along and I would say, well, that can't be right. And finally, after, it was probably a couple of years of that, and I started dissenting almost immediately in a death penalty case, in the Anthony Williams case. And I think I was the only dissent in that case. And ultimately, a federal judge ruled in his favor, and he was resentenced to life in prison. So I was seeing that incrementally, I was seeing that my court wasn't siding with me, but some federal courts were starting to step in and agree, not directly, but rule in the way that I was wanting my court to rule. And that started happening more and more. So by the time the Moore case came along, that was about the midpoint of my 6-year term. By the time that case came around, the court again was the same court that had written the Briseno factors. So the state habeas counsel was asking the court to undo the factors that the people in the room had created. And that was a no-go pretty much from the beginning. They wrote it, they weren't going to undo it, and meanwhile, they'd been enforcing it for 10 years, and meanwhile, people had been executed under those Briseno factors. There was no way that this court was going to abandon the factors that they had created that people had been executed under. Again, when I did not write those factors, I had not been on the court at that time. But again, I was the only one. The court had gone unchanged for 10 years. So when I saw the local council's habeas petition on the Moore case, I read it and it was almost laughable to me, that they were using stereotypes about what, the neighbor thought about Bobby Moore, the use of stereotypes to decide whether he met their expectations of what an intellectually disabled person should act like. I mean, that's literally what the court was saying. And then to make matters really worse, the court had used this example of Lenny, a fictional character in Of Mice and Men, and the court said, well, everyone would agree that Lenny, by virtue of his behavior, was someone who was intellectually disabled. And to me, that made as much sense as saying that, well, if you're as smart as Einstein, well, then you're smart. But if you're not as smart as Einstein, well, then, you don't meet that criteria. I mean, it was nonsense. When I read it, I just thought there's just no way. But again, I couldn't convince a single one of them, and the case was decided 7-1-1. One of the prosecutors, I think, had some kind of contact with Moore, at some prior contact of some sort, and he recused himself. But, it was difficult for me to stand up against all of my colleagues because, they'd been around a long time. They'd written the law. The law had been in place for 10 years. I'm not sure if other people had gone to federal courts trying to challenge it, but I'm sure they had. But no one had been successful in getting it undone. So everything pointed to the fact that this would remain the law in Texas. After this, of course, that's when our friend Cliff Sloan steps into the picture. And he does a remarkable thing. He convinces the U.S. Supreme Court to take the case, and I thought that was a victory in and of itself, that he was able to get the review. I was pretty excited about it. I flew to D.C. and I came to watch the oral argument, and it was wonderful to see him stand up and speak. You heard him speak today and how eloquent he is and how persuasive he is, and he was just that way in front of the U.S. Supreme Court. He stood in front of them. I don't think he had any notes then. I'm not sure. I don't think he had any tonight. But he knew what he was talking about. He had common sense and morality and passion. You could tell he felt for Bobby Moore, and he was invested in the case, and it meant so much to him. And I was so excited that I got to see him, so impressed and so excited. So I went home feeling optimistic that this was going to go Sloan's way and Bobby Moore's way. And sure enough, it did. The court did rule in their favor, and they very decisively said that that my court could not use stereotypes to make these decisions, and that the court had to be informed by medical scientific criteria. So the case then got remanded back to my court, and I read what the Supreme Court had written, and I thought, well, this is clear enough. They've basically said that Bobby Moore is intellectually disabled. All we have to do is just say what they said and rule in Moore's favor. And I was pretty stunned when my court just said no, that they said that Moore was still intellectually disabled and that he was still eligible to be executed. It was a pretty shocking decision as I saw it, and I just kind of saw it as them just kind of daring the Supreme Court to make them. You know, they just were not going to change. After that, again, I dissented. By that time, we had two new judges who had just joined the court. They joined my side, and I really tried hard to try to get another couple of judges to come my way. But they were the ones that had written the Braceno factors. They were just not going to do it. So then Sloan again came forward, and he got the U.S. Supreme Court to take the case again, and things looked pretty good at that point, because I couldn't imagine why the U.S. Supreme Court would take the case again if it wasn't intending to reverse the Court of Criminal Appeals. And one of the more interesting opinions was one, I think it was a concurring opinion by Chief Justice John Roberts, and he said that the Court of Criminal Appeals had applied what they'd written here and there. And I just thought that was such a funny way of phrasing it, because I thought that's exactly what they did. They took what they had written the first time, and then they took what the U.S. Supreme Court had written, and then they just tried to piece them together as if they could still do what they wanted to do by plugging it under the new standard. And I thought that was a very subtle way of calling them out by just saying, no, it doesn't work like that. So that was a happy ending. It was an even happier ending when Bobby Moore was paroled, and Cliff told you about that as well. But since then, he is correct. And I think the most important thing to take from this is that he did not just save Bobby Moore's life. He saved the lives of, I think it is 20 people in Texas who were on death row because of the Braceno intellectual disability factors. And because of the Moore decision, the Court of Criminal Appeals had to go back and reassess all of the intellectual disability claims in those 20 cases, and those individuals were taken off death row and are now serving life in prison. But the effect is even broader, as you all know. In the United States, the case has had a broader impact. And it's even had a broader impact in Texas because now at the front end, prosecutors have to make the correct decision using the Moore standard. Before at the front end, they were doing the Briseno analysis and seeking the death penalty against people who should never have even had a capital punishment trial in the first place. And so it's had a broader effect of keeping people off of death row at all. So it's even broader than the 20 people that we've talked about here. I know the night is long and we've been here quite a while. I just wanted to leave you with a quote from the Dalai Lama who said, just as ripples spread out when a single pebble is dropped into the water, the actions of individuals can have far-reaching effects. And that's the way I feel certainly about Cliff Sloan, but certainly about all of you in this room. You're working hard, you're trying to reach whatever change you can reach. As you've heard from my court, it's going to be incremental. I think it's going to take a shift in the people on the court. 3 of the judges, including presiding Judge Sharon Keller, who was there for 25 years or something as the chief judge on the court, she just lost the primary election. And Texas will have a new chief justice starting January 1st of next year. And I honestly don't have a read about how that's going to turn out, whether it's a Republican or a Democrat. The Democrat candidate is fantastic. The Republican candidate, I don't know as much, but I do believe that he served on some kind of judicial ethics board or something like that, and that is a positive sign that he may be interested in taking the court ethically forward. I think it was ethically challenged for a number of reasons for quite a while. And so hopefully the change will be a good thing. I think it's going to be a little scary at first because nobody really knows what's going to happen. One of the well, anyway, I won't go into too much detail. If you ever have questions, email me or call me, and I'll give you whatever insight I can as to the court. I used to be able to give you just a really good read about how a case was going to turn out and what kind of arguments might be persuasive. I've lost touch a little bit with the court, but I still do have my pulse as to what's going on there for the most part. And so if you are in front of them and you do feel you need a little information, I will help to the extent that I can. I am honestly so impressed with everyone in this room and all of your hard work and the uphill climb that I know y'all face in all of these cases. But I can tell you I do see the incremental changes that I believe will eventually happen. The last thing I wanted to say is I see y'all in your suits and in your professional dresses. I think about that expression that not all heroes wear capes. And so in my mind, all of y'all are heroes here tonight. Thank you.
Thank you so much, Judge Alcala. That was wonderful. I agree wholeheartedly that the change may be incremental, but it is happening. You never know who is listening, who the lone voice of dissent may be that suddenly gets listened to by a majority of the U.S. Supreme Court twice. So I commend you all on being those change makers for everything you've done. Congratulations again to our award winners. I know we are running very short on time here, So I just want to encourage you all, if you are already working on cases, that's great, but think about whether you might be interested in looking at maybe one more. For those of you who aren't working on cases, we would love to talk to you about how you could get involved. There's some materials in the very back corner over there if you haven't seen them, including some very urgent cases that we need help on. As I'm sure tonight has made clear, the need for your help has not passed. This is not something that we are celebrating a final victory on. We are in the middle of the fight. It is worth celebrating all that we have accomplished, but there is still so much more to do. So I hope you will all join us in that fight. Thank you to those of you, many of you in this room who already are there with us. And also just a reminder to stop by the author table out there. We have some great and inspiring books. So if you're not inspired quite enough yet, go read a few books and then come talk to us. We're happy to work with you. Thank you all for being here. Thank you to the folks on the live stream. Good night.